wanting to serve a Section 21 notice before we reach the last chance saloon that later this year when the Renters' Rights Act abolishes Section 21, but you're wondering where you can find an easy to understand step-by-step guide. By the end of this video, you'll understand how to complete Form 6A yourself and what you need to do to serve a valid Section 21 notice. I'm Suzanne Smith, lawyer turned landlord, and I run the Independent Landlord website and this YouTube channel. I do this to provide straightforward, practical, and balanced information for landlords and property businesses. There's a written version of this YouTube video with even more information, which you can find here, theindependentlandlord.com/section-21-notice. Right, let's get started. First things first, what is a Section 21 notice? Well, a Section 21 notice is a form called Form 6A that you need to serve if you want to obtain possession of your property using Section 21, and that means you don't have to give a reason to do it. However, there are a few hoops that you need to jump through to do that. Where can you find Form 6A? Well, you don't need to pay for it. And it's always best to go to the government website because they do change the form from time to time. And you want to make sure that you're always using the most up-to-date form. So here's the link. And this is what you do now. This is where you find all of the assured tenancy forms, including the one that I've done a video on, Form 4, which is for rent increases. But for Section 21, you need Form 6A. So you click there and it takes you through here to Form 6A. Now, there are some notes that are really good for you to read, so I suggest that you do that. But to get the actual Form 6A, you click on that here and it will download as a Word document. And as you see, it opens into a Word document here, form number 6A. So there's a bit of information at the top. It's actually a very simple form. Form 6A is addressed to the tenant and it explains what they need to do when they receive it. And so for the landlord, you fill in the full name of each of the tenants here. And number 2 is you have to fill in the date that you want them to move out of the property. So make sure that that date is 2 months after you serve the notice or on the tenants, plus a week as well. And then when you scroll down a bit, you add in your address or your landlord's address, you sign it and date it and explain. You tick here whether you're a landlord, joint landlord, etc., and you date it. And that is all there is to it. The form itself is very, very simple. When can we use Section 21? So I'm recording this in early January 2025, and these are the rules in place now. So the notice cannot be served in the first 4 months of a tenancy. So you have to serve it, which means giving it or sending it to the tenants at least 4 months after the start of the tenancy. But also, if the tenants don't move out by the date in the notice, the landlord must issue proceedings for an order for possession within 6 months of serving the notice. So don't get caught out by that and serve it too early and then not actually have enough time to issue proceedings before the 6 months expires. So when it comes to the 2 months notice, if it's a periodic tenancy, the notice doesn't have to coincide with the end of a rental period. It does make it easier if it does, but it doesn't have to. And although the notice can't expire during a fixed term period of the tenancy, and unless there's a break clause or another clause that says this, the landlord can serve the notice during a fixed term, so long as the 2 months notice expires on or after the end of the fixed term. And if you've got a 12-month contract, then make sure you don't serve it too early, because if you serve it at month 4 and then you've got 6 months before the notice will actually expire, then you won't ever be able to enforce it, because you need to enforce it after they haven't moved out. So do allow enough time for that. Let's talk about the hoops that landlords must have jumped through to be able to serve a valid Section 21 notice. If the tenant has paid a tenancy deposit, then the landlord must have protected that deposit in a deposit protection scheme within the first 30 days of receiving the money. And they also must have provided the prescribed information to the tenant with the certificate signed within 30 days following payment of the deposit. Second, the landlord must have provided the tenant with a valid gas safety certificate signed by a gas engineer, also an EPC, a valid EPC, and an up-to-date how to rent checklist before the tenant moved into the property. Although if this hasn't happened, it can be rectified, and I'll get onto that in a minute. Note that you don't actually have to provide an EICR, which is an electrical installation condition report, to be able to use Section 21, although that is a separate landlord obligation. The landlord must give tenants a copy of any replacement gas safety certificate signed by the engineer once the originals have expired. And if the tenant entered into a new fixed term tenancy or the fixed term tenancy became periodic after the expiry of the initial term, then the landlord should have given them the latest how to rent checklist. Now, as I'm recording this, the last how to rent checklist was out in October 2023. So if you've renewed since then you should make sure that you send them the how to rent checklist before you serve the Section 21 notice or at the same time. If the property needed a license, so say an HMO license or a selective license, then you must have a valid license before you serve Section 21. Otherwise, Section 21 won't be valid. It also mustn't be a revenge or a retaliatory notice after a tenant has complained about their housing conditions. Now we'll get on to which mistakes landlords can fix and still serve a valid Section 21 notice. If the landlord didn't provide the gas safety certificate, EPC, and an up-to-date how to rent checklist before the tenants moved into the property, they can rectify this and evict tenants. However, they must have at least had a gas safety certificate that was valid before the start of the tenancy, even if they didn't serve it on the tenants. And if they did not have a valid gas safety certificate before the start of the tenancy, then they won't be able to use Section 21. The situation is more complicated with the deposit. If the landlord didn't register the deposit in a deposit protection scheme within 30 days or give the prescribed information, then the only way that a landlord can serve a valid Section 21 notice is by giving back the deposit to the tenants before serving the notice. Now, this won't be popular with landlords if the tenants are already in rent arrears, but rules is rules. This is what you have to do. Once you give back the deposit, then you will be able to serve a valid Section 21 notice, assuming that you've done everything else. And just a little note here, usually tenants pay the deposit after the tenancy agreement has been signed. And so if the prescribed information is only in the tenancy agreement and it's not served after, after they've paid the deposit, then technically you've not served the prescribed information. And there's been recent case law about this, so it's something to be aware of. So there are different ways to serve the notice, and I'll go through them one by one. First of all is in person, and it's best to go with a witness and to take a photo of the envelope being posted through the door or through the letterbox of the property. And you can take a little video and it'll have a timestamp on it. And if the tenant isn't at the property or refuses to acknowledge receipt, you can complete what's called a certificate of service, and here's a link to it here, saying how you served the notice in person. And that way you can have that as evidence if they do contest that the notice was ever served. I do be aware that there are some rules about when the service is counted as starting. So first of all, you have to serve the notice in person before 4:30 p.m. on a working day, on a business day. So that means if you serve it at 5 o'clock on a Friday night, then that notice won't count as being served until the Monday morning, assuming that the Monday isn't a bank holiday. So this is why it's a good idea just to add an extra week on top of it. The second one is by post. So you can serve a Section 21 notice by first class post, but do try to avoid any dispute as to whether or not it was sent. And a simple way to do this is to ask for proof of posting from the post office. And you can take a photo of you handing over the envelope at the post office. The law deems the notice to have been served the second day after it was posted, provided it was posted on a business day. And if the second day is not a business day is Monday to Friday, apart from bank holidays, it will be the next business day. So if you post it on a Friday, although 2 days later would be Sunday, but as Sunday isn't a working day, the notice will be deemed to have taken place on the Tuesday, because so you have to add 2 working days for it. And again, you can fill in the certificate of notice form N215 that I mentioned before. Once you've got a valid Section 21 notice and it's been served, and then the notice expires, but your tenants don't move out, well, what do? Because they don't actually have to move out on the date in the notice, although most of them do. And this is because the only way you can make them leave the property is by going to court. And this is the county court. And you apply for a possession order using the accelerated procedure for Section 21. And then once you've got that order, if they still haven't moved out, then you'll need to employ bailiffs to go around to enforce the order. So just because the notice has expired doesn't mean that you can go and change the locks or go shout at them and ask them to leave. That would be an illegal eviction. You have to go through the proper process. And if you're in this situation, I would use specialist solicitors do it, because unless you're very, very confident at all the forms, it's best to get an expert involved and make sure that they're a proper solicitor regulated by the solicitors regulation expert and not some eviction outfit that promised the world. But the thing about Section 21 is that the judge must give possession of the property back to the landlord if the notice is valid, and the outright possession order will give a date for possession, which is normally 2 weeks later, although there will be a delay. There are delays at the moment in this. And if the tenants are still in the property on the date for possession, the landlord will need to obtain a warrant for possession, which is Form N325, to have them evicted. And there's a procedure for that. And the final stage is repossession, or enforcing the order by having a county court bailiff or high court enforcement officers to carry out the eviction. And this is the only way that landlords can legally require tenants to leave. Now, I know a lot of landlords do DIY this at the moment, but as the closer that we get to the Renters' Rights Act coming into force, the less opportunity there is to fix mistakes. So I really would use solicitors and not just rely on YouTube videos or blog posts on what you have to do. Do get some help for it, because if you make a mistake, you may run out of time depending when you're watching this, and it'll be too late to serve another valid notice and do it properly. And once Section 21 is abolished, then we'll all have to use the Section 8 procedure, and I explain what happens in this video here. If you want to keep up to date with what's going on, you can also subscribe to my weekly newsletter at theindependentlandlord.com/subscribe. Finally, here's where to find other practical how-to videos to help you succeed as a good landlord. See you soon.